So, the Supreme Court has issued an order in a critical Second Amendment Preservation Act challenge that was pending in front of them. So, let's talk about what happened in this case and where it goes from here. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, double check to make sure YouTube has not unsubscribed you. And also, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AO is in a league of their own. They're backed by an actual law firm, and they're always expanding upon their benefits. One of the things that they're doing right now is they just added a guarantee that if you're in a self-defense situation and you're a member, they will give you 4 attorneys for your case. So again, check out AO using the link down below. And if you sign up using my code ARMScholar, you can get $50 off of an individual sign-up plan or $25 off of a family plan. As I mentioned in the intro, in this video, we're going to be talking about a significant Second Amendment Preservation Act case that was seeking Supreme Court emergency review. This is a case dealing with the state's Second Amendment Preservation Act. And we've discussed this case before because in the past, the Supreme Court issued an H-1 order denying a stay which would have protected Missouri's SAPA law. This case went back in front of the Supreme Court, and recently we got the answer from the Supreme Court. The Supreme Court in a recent order list denied emergency review to the Missouri SAPA case, but this case is far from over and it's not done yet. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should deny review to this case. However, at the same time, they stated that if the court denies review, the government will actually release some of the judgment that they received prior the B administration had got a complete judgment from the lower court. And so here, the Trump administration said to the Supreme Court that they would release some of that judgment. The administration told the Supreme Court that once this case got back in the hands of the lower court, they would release some of that judgment that they got. Missouri responded to this by pointing out that that concession made by the Trump DOJ is exactly why the Supreme Court should have granted review to this case. This case then went to the Supreme Court back in September for conference. But unfortunately, the Supreme Court ultimately agreed with the Trump administration, and they took their word that they would actually release some of that judgment, and so they denied emergency review to this case. Now, this lawsuit revolves around a 2021 law that was passed in the state of Missouri called the Second Amendment Preservation Act, or the SAPA law. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies like the ATF in their attempts to enforce federal laws that are believed to violate the Second Amendment. The law prohibits misuse officers, agents, and government officials from helping federal agents like ATF agents who are attempting to enforce those inconsistent laws. The law also created a civil remedy where anyone could sue a Missouri official if they helped to enforce a federal law that violated the Second Amendment. So, the law aimed to give the true enforcement powers to the residents instead of the state or any of its officers or agents. In this Missouri case, the district court on review ruled in favor of the Biden administration, striking down the Missouri SAPA law entirely. Now, in response to that, the state of Missouri appealed up to the 8th Circuit, and Missouri at the time wanted a temporary stay on that lower court ruling, which was a complete permanent injunction on this case. And that was denied by the F Circuit. And so, at that time, the state of Missouri decided to seek emergency Supreme Court intervention. And that was the first time that they went to the Supreme Court on an emergency basis. However, on review, the Supreme Court issued an 8:1 order denying that emergency stay. Only Justice Thomas was in favor of stepping in and granting that state. So, after that, the case was sent back down to the 8th Circuit, who then held expedited arguments in this case, and the ETH Circuit ultimately ruled in favor of the federal government once again, striking down all of the SAPA law. But then Missouri decided to once again go to the Supreme Court on emergency basis with a new SCR petition. One of the big things that Missouri points out is that the F Circuit essentially said that the structure and operation of this law is valid, but they ultimately struck it down because of its underlying purpose, which was to protect the Second Amendment. Missouri argues that the Eighth Circuit went against clear precedent and found that state officials could be sued because the court believed that the state played a role in enforcement of the law by simply complying with the state law, which told them to essentially not do anything. So not doing anything was actually doing something. Now, this law was originally opposed by the Biden administration, but now the Trump DOJ, of course, has control of this case. And initially, they stalled out the response for multiple months in this case. But then we received their answer in this case. And in the response, the Trump administration continued to argue that the SAP law is invalid in some of its applications and that the lower court got the decision correct. However, at the same time, they argued to the Supreme Court that the Supreme Court should deny emergency review to this case and instead let this get back down to the lower court for a final merits decision. And they stated that if that happens, the Trump DOJ was willing to release some of the permanent total injunction that the Biden administration got from that lower court. So, they said that they would release some of that judgment. They argued in that response that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of the federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in the pre-enforcement posture about how certain provisions of this act will be applied and about whether the provisions on which the Eighth Circuit focused are indeed inseparable from the rest of the act. Given those concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment when the district court regains jurisdiction over this case. So after stalling the case for a few months, the Trump DOJ responded by continuing to argue against the SAPA law. But at the same time they said, Supreme Court, if you deny review to this case, we will release some of that judgment that was granted by the lower court. And ultimately, the Supreme Court sided with the Trump administration in this case, and the recent order list from the Supreme Court decided to deny emergency review to the SAPA challenge. Now, despite that denial, this case is not yet done, and it will still move forward at the lower court level. As the United States stated in the request for the denial in the Supreme Court, once this gets back in the hands of the lower court, it will head towards a final merits determination. And also, at that time, it will be on the Trump administration to decide if they will actually stay true to that promise and release some of that complete injunction that was won by the Biden administration. So there may be some ways in which the SAPA law will be implemented while the case moves forward towards a final judgment in the lower court. So even though the Supreme Court denied emergency review to this case, it will move forward at the lower court level, and the Supreme Court will send this back down to the Western District of Missouri, and the United States government claims that they will be actually releasing some of the judgment that they got before. Now, whether or not they stay true to that, we will have to wait and see. But that is at least what the Trump administration argued in the Supreme Court for this to be denied review by that court. So unfortunately, once again, the Supreme Court denied emergency review to a two-way case and denied getting involved in this challenge right here now. But there is still hope and positive movement in favor of keeping the Missouri SAPA law in place in some of its applications. And that is based on the Trump DOJ saying that they're going to release some of, the total injunction that they got, maybe let some aspects of the enforcement go into place and really see how does that play out. So, as we get more information as this case develops, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. Also, you can check out one of the two videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.